Hello and welcome to Skills to Pay the Bills. In today's segment of JustAskFreeman.com. Sitting next to me is my lovely wife and co-host, Carolyn Owen. Our special guest today is nationally known elder law attorney and is the founder and shareholder of the estate planning and elder law firm PC. He has represented over 6,000 clients throughout the Washington, D.C. metropolitan area. In addition to practicing estate and incapacity planning, his law firm also practices Chronic Care Advocacy, which incorporates on-staff social workers into the life planning process. Now, prior to founding the law firm, our guest worked as a trust officer with First American and First Union banks, during which time he was responsible for over 100 personal trusts with market value assets exceeding $40 million. He's also a graduate of the University of Virginia and the University of Baltimore School of Law. Ladies and gentlemen, please welcome William Bill Fralin, Esquire, to our segment of JustAskFreeman.com. Welcome, Bill.
Thank you, Freeman. Thanks for having me. It's great to be here.
Bill, it is such a pleasure to have you here today. And I want to know, can you give me a little bit more information about the background of your firm, about your experience?
Absolutely. Well, I'd started as a trust officer and started a traditional trust and estate practice, doing wills and powers of attorneys. And then as time passed, people would come in and say, we have these documents in place, but now my mom, my dad, my spouse is not well. What do I do? And I said, well, I did the documents, and they said, that's great and wonderful, but I'm not sure what to do. So it led me, and I couldn't give them an answer, and it didn't feel right. I should be able to advise them with the full picture. So what happened is that eventually I would consult with social workers who said, oh, this is what you need to do. Here's the right protocol. Here's the facility. And eventually, in the firm, we added social workers, which the first attorney in America was the first person named Tim Tekes out of Nashville. In '92 was the first elder law attorney to have a social worker. Set a trend, and many people followed. And now, at this point, we're 3 social workers and a nurse. So that in addition to the estate and incapacity planning, we also do chronic care advocacy, so that if someone has a chronic condition, they get a diagnosis, they get a stroke, they have a break, that not only can we make sure the documents are in place so we have decision-making authority, but we can make sure that they get good care and that they preserve their assets in the process, because one without the other is a half victory. So the point is to get the good care and preserve assets, which is a part and parcel of securing that good care.
And I would assume with some of the baby boomers that this practice is probably growing significantly.
It's not only growing; it's exploding.
Okay.
And for what used to be known as the sandwich generation, they're now called the panini generation, because not only do they have work and children, but they have aging parents, and so they're under pressure from both sides. And with the aging American population, it's just growing by leaps and bounds. And because in the 50s, we drank, we smoked, we ate eggs and bacon for breakfast, and we had heart attacks at 50. Problem solved itself. Now we're living longer, but we're living with chronic conditions, which change. Once that chronic conditions occur, it changes planning. So we have all the work we can do.
Sure.
I have a question for you in reference to planning. Now, you said you are involved in the estate planning. Does that encompass retirement planning, where you use specific products in addition to the different types of documents that are needed for living trusts?
Well, absolutely. With estate planning, there's a number. I mean, with estate planning, you're planning for when bill passes, what happens. And some common products are, for young families, it's a must, life insurance. Because if you're gone, how are you going to pay to educate your children?
Income, yeah.
The life insurance, or how is your wife or your husband going to to replace your income? And so, or we could say, while they're doing the planning, disability income. If you get disabled, I mean, you may not be dying, but again, these are issues that a good advisor can help you with and say, here are the things to think of. But insurance, long-term care insurance, or looking at paying for the cost of care, paying for funeral services, all of these things that are things that could be considered now while you're competent, so you can make informed decisions.
Exactly. Now, one question came to mind here. I wanted to ask you, what do you find in terms of the awareness of the seniors in regards to elder care? Are they familiar with the different aspects of elder care?
I find that overall there is a shockingly low level of awareness with elder care. Most people will agree that they need to have a will in place, but very few understand the need for planning, because the greatest risk people face is not as if they die, it's if they live with a chronic condition. And so, and I've run into doctors, professionals who they don't know. And particularly the seniors, they have a false sense of security that, well, I will do a will and everything's gonna be okay. They might get lucky, and that may be the case. But again, it's not a good approach if you want a good result for your family and for your loved ones.
All right. Let's elaborate a little bit more on your services. How they may be helped beyond the life insurance now, and beyond long-term care, and beyond disability.
Certainly.
And let's bring in the legal aspect of.
Certainly. Well, everyone over 18 should have a basic set of documents, which include estate planning, which is a will or a trust.
Right.
And that simply says, when bill passes, here's who's in charge, here's who gets what, and here's the manner in which they get it. If they're minor children, we don't want to give them all at 18.
That's it.
That would be a bad idea for me, and I assume it will for the children. But I believe is more important is incapacity planning. And those are a financial power of attorney, a medical power of attorney, and an advanced medical directive.
Right.
Now, these are while you're alive. Powers of attorneys end when you die. So one gives the ability to pay your assets, pay your bills, keep your credit in good shape. The other is to make non-terminal medical decisions. The advanced medical directives is to say, if you're in a terminal condition, what your wishes are. Right. And regardless of network, regardless of marital status, we're all mortals. So the truth of the matter is you need to have these. And I even have I have people with children in college, and they have a bike accident, and the college won't talk to the parents because the kids are over 18. And they won't give them their grades. So I just have some parents send in the kids specifically at the holidays to get the powers of attorney because they want to know what they're paying for. And if their child's not well, they can talk to the hospital.
Boy, that's amazing. That's news to me.
It's news to a lot of people. Yeah. And when the crisis occurs and the hospital says, "Do you have your HIPAA release?" You say, "I'm this person's parent." They're like, "I understand that, but." The hospitals are litigation adverse, so they're not going to take any risks. So it may be an inconvenience to you, but they're more concerned about their own protection than accommodating you. Exactly. So the planning is critical. And again, your age is a factor, because actuarially, if you're young and healthy, you're probably a good bet.
Exactly.
But as you age, your actuarials decrease. And so it becomes more important, and particularly as you age, when you have children, it's not just you, it's other people too. So it's making sure that your whole group of loved ones and family have these in place so their decisions will prevail. Exactly. If you don't do that, the states have an intestate statute that will make the rules for you, and you may not like the results that they have.
Now, what do you feel is the best, hypothetically, the best characteristics for a senior that is prepared for elder care? What should they have, and what do they need to do? What are some of the steps involved?
Well, a senior that is prepared has, one, secured the documents for estate and incapacity planning, and also they have a relationship with a seasoned professional. Because I call LegalZoom legal doom. Because doing it yourself, if your spouse has a stroke, you can go on the internet and say she's not well, and they might. Good luck with them getting back to you. having the relationship with the professional, you can say, okay, well, this has occurred in my life, that's occurred, is there anything I should be aware of? And if there's a change in law, the attorney will let you know. And in addition to, while you're healthy, we recommend the clients gather their personal data, birth certificate to last bank statement, and also their medical data, so that it's not in shoeboxes in the basement, but we have a spreadsheet. We have it collected, and we as a firm with all clients will give a list and say, get these things, don't get them all today, but collect them while you're healthy, because when the crisis hits, if we have all the data, decisions are a lot easier. And there's a lot less stress and headaches. And it's been my experience, no one's ever come off and say, Bill, I just don't have enough headaches.
Right.
I'd like some more. So by having that, they're prepared, and then the decision making is far simpler.
So what I'm hearing from you is that you definitely need to have a power of attorney and seek legal advice early on, it sounds.
At 18, I mean, at 18 is the earliest you can secure this. But for anyone who, but everyone at some point should do it. And the older you are, the more important it becomes. Because if you fail to have a power of attorney, the alternative is a guardianship. And a guardianship is a proceeding wherein they testify that Bill's crazy for the following reasons. And if they prevail with the judge and the judge agrees, my rights are taken away, and I have someone appointed as my guardian who effectively is my surrogate parent, who can tell me how I'll be living my life, and they'll be managing my assets. And this situation comes up when dad doesn't do his documents, has dementia, and then it's gotten beyond the point where we can get a power of attorney. We have to go to court, and I've seen situations where children are testifying against their parent, saying, well, dad does this and that, and he already is paranoid by virtue of the disease, and it forever shatters family harmony. It is a completely avoidable tragedy. The three cases, Nancy Curzon, Karen Ann Quinlan, and I can't think of the third one, these are all cases that they didn't have powers of attorney, and it went to the Supreme Court. And in a guardianship proceeding, they decided to let them end artificial life support. But again, it bankrupted the families, heartbreak. It's the wrong way to do it.
Now, I read somewhere that as many as 70% of the American elderly are ill-prepared. So what all do you need? And if I have a power of attorney, am I safe at that point?
If a power of attorney, you want to have a power of attorney drawn up by a seasoned professional, because frequently powers of attorney are drawn up, they're strictly for estate plan. It's like, you can pay my bills. But an elder law attorney is going to incorporate asset protection planning, meaning I can restructure your assets so that we can help pay for your cost of care. Without that language, I have to go to a judge, ask say permission to have the assets transferred or restructured in order to qualify for the different programs, which is a long, expensive process. By having it in the power of attorney, which I think is the most important document, a financial power of attorney, the ability to structure assets consistent with asset protection, then you have taken all the steps until the crisis occurred. You need to have the ability to take those actions.
All right, we're going to take a break here, a short station break, and we'll be back shortly. Stay with us.
Taking care of a family member can lead to plenty of questions. Fortunately, there's a place to get the answers, for them and for you. Find articles, tips, and tools from experts and others who have been in your place. The Caregiving Resource Center at aarp.org/caregiving.
For those of you who are just joining us, you're watching today's segment of JustAskFreeman.com. Our special guest today is Attorney Bill Fralin, principal of the estate planning and elder law firm PC. Now, Bill, prior to the break, we were discussing the percentage of the elder population that are ill-prepared, and if one had a power of attorney, were they safe? Now, our practice, we do a lot of retirement income planning, and we bring in the helping others when to file, how to file for Social Security, to coordinate the income gap, and also we look at Medicare.
Sure.
We've got 10,000 boomers that turn age 65 every day for the next 10, 15 years or so. So when we bring in long-term care or skilled care, how is that coordinated with Medicare, Medicaid, and long-term care when it comes to providing the long-term service, or I should say skilled care for that individual that visits your office that you take care of? And could you explain the difference, or could you explain how these three components are used?
Absolutely.
And how does it work?
Well, essentially, there's three levels of care. There's independent living, which is what we get up every day, we brush our teeth and go to work. And that's a large segment of the population. The second level of care is assisted living. The sunrises you see on the way to work. These are relatively 30, 40 years recent development, that it's an intermediate level of care, and it can go from just a very low level, Bill, take your medicine, you're much nicer when you do so, to up through, Bill, you need assistance with eating and any other activities of daily living. The third level of care, and which is the greatest financial risk, is skilled nursing care. That is when I get to the point that I require assistance with two or more activities of daily living, grooming, bathing, eating, toileting, etc. Then at that juncture, the only available facility that can provide the care is a skilled nursing facility. Now, why it's such a problem is in the Washington metro area, that cost of care is $10,000 to $12,000 a month.
Exactly. Yeah.
Which is staggering, even if they plan with you, Freeman, and have done very well. So there's three ways to pay for this care. One is if you're unprepared, you simply write checks in your private pay.
Right.
The second is long-term care insurance. And again, it's the best option. Some people can't qualify, but it's option number two. Option number three are entitlements. And there's essentially three. There's VA. If someone is a veteran, there's a number of programs depending upon your service and if you have a service-related illness. And so that's something to check into. They have multiple programs if in fact you are a veteran. Medicare is the insurance for people over 65. Now it has four parts. Part A is hospitalization. Part B are doctor's visits. Part C is an HMO where Kaiser runs this for you. And Part D is your drug benefit. Exactly. Now for long-term care, Medicare only pays under Part A hospital. If you're in a hospital and you're admitted for 3 nights, and they have, if that's not for observation, but admitted, then they will pay, under Medicare, they will pay for up to 100 days for skilled nursing care. And the goal of the government, and they pay very well for this, is to get Bill better. Because if they do, then they no longer have to pay for his costs. So the government is willing to pay very well for this. But for a long-term care benefit, the most you will get is 100 days, which leaves the final area, which is Medicaid. And this is part of the Great Society program. Medicaid pays for long-term care. It pays for 65% of all the skilled nursing beds in America. Because again, at $12,000 a month, it's not going to take long for the average American to deplete all their assets. And so if you meet that level of care, require assistance with 2 or more activities of daily living, then you qualify on a health care on the healthcare side of the equation. Then they will look at your assets. The general rule for Virginia is you're allowed to keep $2,000. Maryland's $2,500, and the district is $4,000. But under Congress created rules in 1988 called the anti-impoverishment rules, so saying that, for example, for a married couple, they can keep the house, they can keep a car, they can keep the contents of the home, and the well spouse can keep their income and keep up to $120,000 in a community spouse resource allowance. And there's other planning techniques too that are available. And so, but those essentially are the 3 ways to pay. There's no other. And so when you do the estate planning, this is as important or more important, because if you pass, well, the problem is solved.
Exactly.
And again, but we're living longer with chronic conditions. And so it's become more and more of an issue and a bigger cost. And so knowing that those are the options, then having your power of attorney, which lets you, if you need to access any of those, you have the ability to do so.
You know, Bill, now the average stay in a nursing facility is about 2.9 years. Can you imagine $12,000 a month? It's 120 grand a year. There's over 300 and some odd thousand dollars in assets that would have to be depleted in order to pay for this care. Now, you mentioned the fact of, or you talked about Medicaid or an entitlement. This Medicaid, referred to as Medicaid spend down.
Correct.
Yeah. The rules have changed, as you said. At one time, I think you can only keep $2,000 in cash value, of course, to be working, or I should say the healthy spouse could retain the home.
Correct.
But there are various methods in order to avoid depleting all your assets.
Absolutely.
Now, something else, one question I wanted to ask you. Speaking of Medicaid spend down,
Certainly.
what if you have a special needs child that is receiving benefits? Now, you've indicated in your will or your living trust that you'd like to make sure that that special needs person is taken care of in the event of your death.
Certainly.
What are some of the means that are taken if that special needs child is receiving an entitlement?
Certainly.
Say, they have a disability.
Certainly.
But we also know that if the special needs person is receiving these benefits, I should say not benefits, receiving the benefits from SSI or SSD or whatever, and if the legacy they're receiving exceeds a certain level or a certain amount of money, would that benefit be cut off?
The special needs trusts were created by Congress, and they were because the entitlement programs we mentioned before are designed to provide food, clothing, and shelter. But special needs refer to needs over and above those basic survival needs.
Okay.
And so Congress created the ability to create a special needs trust, which means this is for my loved one. So say a disabled child, I can place money into this trust, and while it's owned by the trust, it may be used for the special needs of the child. And as such, then when the child's trying to qualify, because remember they look at your finances, these monies don't count. You could put $1 million in the special needs trust. And again, this happens in situations where they have car accidents and someone will have needs the rest of their life. They place the funds into a special needs trust, and then the person can receive, the SSI, SSDI, Medicare, Medicaid, whatever program it happens to be, Section 8 housing, and it doesn't affect it. So in your planning, you want to this is one of the means in planning, if you have someone who has special needs, to give it to them outright is a mistake.
That's a big mistake.
It's a big mistake, and again, people have the best of intentions, and they will buy insurance and get a lot of money to care for this person, and had they simply put it in a special needs trust,
the distribution.
it would all be exempt. And sometimes you can petition the court to say, look, this person's not a lawyer, and they meant to do this, and please let us do it, Your Honor. And frequently they will, but again, the easier way is get it right the first time.
Exactly.
Because, and also too, there's something with Medicaid, if you have a disabled child, you mentioned with Medicaid there's a 5-year look back, and what that is, that's a rule that says when you file for Medicaid, they ask you, Bill, have you given any gifts within the last 5 years? The rule does not apply to spouses, so that's a planning opportunity. But if you have given a gift, you aggregate them all, how much and when, and then if you gave a small amount, you have a short period of ineligibility. If you gave a significant amount, you have a much longer period of ineligibility. But one planning option, if you can't qualify for long-term care insurance and you're reasonably healthy and you have reasonably good actuarials, is that you can create an irrevocable trust and transfer the assets into that, and in 5 years and a day, you'd be eligible.
Exactly.
Bill and Melinda Gates could transfer the $70 billion into a trust, and in 5 years they qualify. I doubt they're going to do that,
Yeah.
but the point is those are among there's a lot of planning options out there that people, the general public, are not aware of. The facilities make the most money when you pay the $12,000. So they're not going to tell you about this. They would much prefer that you pay the full amount.
All right.
Now, Bill, I know we talked a lot about powers of attorney, but I want to circle back to that.
Absolutely.
Now, many seniors may not know beyond the basic documents what they need, and I know you mentioned
Sure.
the trust. So, what other documents would they need, and what do they need to get things set up?
Well, again, everyone will have powers of attorney. And again, you have the financial power of attorney with the asset protection provisions in it.
Okay.
And then you have a healthcare power of attorney, which is for non-terminal medical decisions. Anything from a headache to heart transplant. It simply says, if I can't make a decision, I'm under anesthesia, then my spouse will do so for me. The advanced medical directive is for terminal conditions. And I like the name of the document because it says, in advance, I'm directing that this is what occurs. And the standard on this is very high. And it says, in the event that 2 doctors who have personally examined me have put into writing that I found me to be in one of 3 conditions, a permanent vegetative state, an irreversible coma, or a terminal condition, then I say in the document I either do or I do not want artificial life support. Why this is beneficial to loved ones is it takes them out of the situation of, oh, am I making the right decision? Advanced medical directive. In advance, Bill's already directed this is what he wants. So you can avoid the conflict and you are in the position of simply enforcing his wishes.
Alrighty. Well, look like the clock on the wall is telling us that our show is just about over. I want to thank you for watching our segment, JustAskFreeman.com. We hope that you have enjoyed our discussion with our special guest, Attorney Bill Fralin. And please give him a call with your questions and comments about estate planning and elder care strategies. And also, do not forget to contact us about our Safe Money Kit on JustAskFreeman.com. And I hope, Bill, that you would return.
Would love
with
to.
Interesting topics. Join us next week, same time, same place, for another great segment. And again, thank you for watching Skills to Pay the Bills in our weekly segment of JustAskFreeman.com. Have a healthy and safe week.